The judge laughed, not a chuckle, not a polite clearing of the throat. A full, open-mouthed laugh that bounced off the wood-paneled walls of Courtroom 4 in the Brampton Superior Court of Justice. Zadie Mensah-Cole didn't move. She was 22 years old, standing in a gray blazer she'd borrowed from a neighbor, holding a manila folder so thick the edges had started to curl. Her twin brother Desmond stood beside her, one hand resting flat on the table like he was steadying himself, or steadying the room. The lawyer on the other side, a man named Rutherford Aldous, who had been practicing family law in Peel Region for 31 years, leaned back in his chair and smiled at the ceiling. "Your Honor," he said, not bothering to hide it. "These two young people are telling this court that they intend to represent their grandmother, themselves. With no legal training, no bar certification, we have a right to act as agents under the Substitute Decisions Act," Zadie said. The room went quiet. She hadn't raised her voice. She hadn't looked at Aldous when she said it. She'd looked at the judge. That's where this story starts. But that's not where it began. Lennox, Ontario is the kind of town that doesn't show up on the maps people actually use. It sits about 40 minutes west of Hamilton, past the gravel quarries and the failed vineyard someone optimistically planted in 2009. It has one Tim Hortons, one hardware store, and one church that doubles as a food bank on the third Saturday of every month. Marvelle Mensah-Cole had lived in Lennox for 43 years. She came from Accra in 1981 with her husband, Kweku, who worked the overnight shifts at the Dofasco plant until his knees gave out, and then worked the day shifts at Canadian Tire until his heart gave out. He died in 2019. She stayed, because Lennox was her home, because her garden was there, because the woman at the post office knew her name and always set aside the seed catalogs for her, even though Marvelle had never once asked her to. She had 2 children, a son named Marcus who lived in Edmonton and called every Sunday, and a daughter named Patricia who lived 15 minutes away and called when she needed something. Zadie and Desmond were Patricia's kids. They'd spent more of their childhood at their grandmother's house than their own, partly because Marvelle made jollof rice from scratch every Friday, and partly because their mother's house was not always a calm place to be. When Marvelle had her stroke in the fall of 2023, it was Zadie who found her. She'd driven out on a Tuesday evening because Marvelle hadn't answered her phone for 2 days, which wasn't completely unusual. Marvelle had complicated feelings about her cell phone and often left it face down on the kitchen counter, but something had felt off. Zadie had learned in her 2 years serving with the Canadian Armed Forces before a shoulder injury ended that chapter, to pay attention to the feeling of something being off. So she drove. Marvelle was on the kitchen floor. She was conscious. She could not form words. Zadie called 911. She rode in the ambulance. She sat in the waiting room at Hamilton General for 6 hours while her grandmother was assessed, stabilized, and eventually moved to a ward. She called Marcus. She texted her mother. Marcus booked a flight. Patricia said she'd try to come by the next day. The stroke left Marvelle with partial paralysis on her left side and significant aphasia. She could understand language, but producing it was slow, effortful, like trying to carry water in cupped hands. She could walk short distances with a frame. She could squeeze your hand when she wanted to say yes. She could not read a legal document and explain what she understood it to mean. That detail would matter later. The house in Lennox was worth something now. Not much by Toronto standards, but by Lennox standards, by Marvelle's standards, it was everything. The market had shifted. The lot was large. There'd been interest. Zadie didn't know any of this until she found the folder. It was in late January, about 3 months after the stroke, when Marvelle was still in rehabilitation, and Zadie had been driving out to Lennox twice a week to check on the house. Water the plants she could keep alive, collect the mail. The folder was on the kitchen table. She almost didn't open it. It looked like junk, an envelope with a real estate company's logo on the front. But something made her look. Inside was a purchase agreement for the house for $340,000, signed apparently by Marvelle Mensa Cole, signed on October 14, 2023. Marvelle had her stroke on October 9th. Zadie read the document 3 times. She sat down. She read it again. She took a photograph of every page. When she called her mother that evening, Patricia said she knew about it, said Marvelle had arranged things before the stroke, said the house was being sold to cover the cost of the long-term care facility, said a lawyer named Aldous had handled everything and it was all completely above board. Zadie asked where the $340,000 was going. Patricia said it was complicated. Zadie asked again. Patricia hung up. Here's what Desmond was doing when his sister called him that night. He was in his 2nd year at Sheridan College studying graphic design, working 20 hours a week at a print shop in Mississauga, and sharing a basement apartment with 2 roommates who kept slightly different hours than he did. He answered on the 3rd ring, sitting on the edge of his bed with his shoes still on. He listened. He said, "How long ago was October 14th? 5 days after her stroke," Zadie said. She couldn't talk. She was on blood thinners. She stopped. She couldn't have signed this. He asked how much lawyers cost. She'd already looked it up. A family law specialist in Hamilton ran between $400 and $600 an hour. A real estate litigation lawyer was similar. To challenge a fraudulent property sale, to investigate undue influence, to argue incapacity at the time of signing, she'd done 3 hours of reading, and what she found was this: they were looking at a minimum of $8,000 to $12,000 just to get started. Possibly much more. They didn't have $8,000 between them. They called Marcus in Edmonton. Marcus had a family, a mortgage, his own complications. He could contribute $2,000, maybe $3,000. Not enough, not close. They called a legal aid clinic. The wait list was 4 months. They called a second one, 6 months. They called a third. The woman on the phone was kind, genuinely kind. But she explained that property disputes of this nature, involving potential elder fraud, were outside the scope of what their clinic could take on. "What about duty counsel?" Desmond asked. "That's for criminal matters," the woman said gently. "I'm sorry." Zadie thanked her and put the phone down. The house in Lennox, the one with the garden, the seed catalogs, the memory of every Christmas dinner, the room where she and Desmond had slept in bunk beds every Friday night, until they were teenagers, was being transferred to a numbered company registered in Ontario. The closing date was 8 weeks away. Nobody would help them. Not one organization in the entire region. Zadie sat with that for about 2 hours. Then she opened her laptop. You should know something about Zadie Mensa Cole before she walked into that courtroom. She was 22. She had a grade 12 diploma, a CPR certification, a certificate from a short college program in community services, and 2 years of military service that had taken her to bases in Petawawa and Shiloh, Manitoba. She had fired a C7 rifle, learned to read a topographic map, and once spent 11 days in the bush in January as part of a winter warfare exercise that she describes, if you ask her, as not something I'd recommend. She was not a lawyer. She had never studied law. But she had done 2 things in her life that turned out to be useful here. The first, she was trained to stay calm when the situation was not calm. Not to perform calm, to actually be calm, to observe, to think, to act in sequence. The second, she read. Not legal textbooks, she hadn't had access to those, but everything else she could find. Court filings available through CanLI, plain language guides published by Community Legal Education Ontario, a YouTube channel run by a retired Ontario paralegal. Every self-represented litigant resource she could locate through the Superior Court's website. She spent 3 weeks reading before she filed anything. Desmond did research too. Different research. He was the one who found the notary public's stamp on the purchase agreement. He was the one who looked up the notary's license number and discovered it had been suspended in 2022. He was the one who printed the Notaries Act and highlighted the relevant section in yellow. He brought it to Zadie at 11 o'clock on a Thursday night, setting it on the table between 2 cups of tea. "If the notarization is invalid," he said, "the signature can't be certified." She read the page. She looked up. "That's the question," she said. "That's the one we need." The motion hearing was on a Wednesday morning in March. Zadie had filed an application to have the purchase agreement set aside on grounds of incapacity and invalid notarization. She'd used the court's self-represented party forms. She'd cited 3 sections of the Substitute Decisions Act, 1 section of the Notaries Act, and 2 case decisions she'd found on Canal I. The clerk who received her filing had looked at the paperwork for a long moment, then looked at her, then stamped it. Rutherford Aldous had filed a response 14 pages long that described the application as frivolous, vexatious, and an abuse of process. He had requested it be dismissed without a hearing. That request had been denied, so there they were, Zadie and Desmond on one side, Aldous and a junior associate on the other, a judge named Girard on the bench who was 61 years old and had, according to the court's public records, presided over approximately 400 property and family law matters in the last decade. And the laugh. That's when it happened, when Aldous made his remark, and Girard laughed. But Girard recovered. He was, whatever else, a professional. He looked at Zadie. "Mrs. Mensah-Cole," he said, "you understand that your status here is as a lay representative, not as legal counsel." "Yes, Your Honor." "And you understand that decisions made in this proceeding will be legally binding on your grandmother as applicant." "Yes, Your Honor. We have her written authorization, witnessed and dated." She placed a document on the table. Desmond passed a copy to the clerk. Aldous said, "Your Honor, I'd like to note for the record that the written authorization presented by these parties has not been verified by." "I can read, Mr. Aldous," Girard said, not looking up from the document. The room was quiet for a moment. "Proceed," said the judge. Zadie had organized her presentation into 3 parts. The first was the timeline. She had built it herself, in a table, printed in 12-point font, with dates in the left column and source documents in the right. October 9th, Marvelle's stroke, Hamilton General admission records. October 11th, initial assessment, aphasia diagnosis documented. October 14th, date of signature on the purchase agreement. October 17th, first speech therapy session. Notes indicating patient unable to produce written language. She walked through it quietly, not dramatically, not with the kind of TV courtroom swagger that makes for good storytelling but actually works against you in a real room. Just, clearly. 1 column, then the next. Aldous objected 4 times. Girard sustained 1 objection and dismissed 3. The second part was the notarization. Zadie placed the purchase agreement on the document presenter. She highlighted the stamp. She read out the license number. "Your Honor," she said, "we obtained records from the Law Society of Ontario indicating that this notary's license was suspended on March 4th, 2022, and was not reinstated as of the date of this document. Under Section 7 of the Notaries Act, a document notarized by an unlicensed individual is not valid certification. The signature on this agreement, therefore, cannot be legally certified." She set Desmond's printed copy on the table. Aldous stood up. "Your Honor, this is. My client had no knowledge of the notary's status. The responsibility for ensuring licensure rests with the notary themselves, not with Mr. Aldous," Girard said. He had not looked up. Aldous stopped. "I have a question." The room went very still. Girard looked at the document. He looked at the date. He looked at Zadie's timeline, which was still on the document presenter. "If the patient, Mrs. Mensah-Cole, was assessed on October 11th as having significant aphasia affecting written language production," he said slowly, "can your client explain to this court how she produced a legible, unassisted signature 3 days later on a document that runs to 11 pages?" Aldous opened his mouth. He closed it. He said, "Your Honor, I would need to. I would request a brief." I'm not asking for a recess, Mr. Aldous. I'm asking if your client has an explanation for this court. The junior associate leaned toward Aldous and said something. Aldous leaned away. Your Honor, Aldous said, we may need to review additional documentation before. Yes, said Girard. I expect you do. He set the papers down. He looked at Zadie. Something had shifted in the room. The air was different. Zadie felt it. She'd felt it before in other contexts, the moment when the situation changes and everyone in the space knows it, even if no one says so out loud. She didn't smile. She waited. Mrs. Mensa Cole, Girard said, does the applicant have any additional materials to submit? Yes, Your Honor. She placed the final documents on the table. 2 affidavits from Marvelle's occupational therapist and speech-language pathologist, both attesting that, as of October 14th, Marvelle Mensa Cole lacked the cognitive and physical capacity to independently execute a legal document. Both signed, both notarized, properly this time, with a notary Zadie had looked up herself. Girard read them. The room waited. The ruling didn't come that day. It came 18 days later, in a written decision Zadie read on her phone at 7:23 in the morning, standing in the kitchen of the apartment she shared with Desmond. Justice Girard found that the purchase agreement dated October 14th, 2023 was void and unenforceable. He found that the notarization was invalid under the Notaries Act. He found that the evidence presented by the applicant's lay representatives raised serious and substantiated questions about the circumstances under which the document had been executed. He ordered the property transfer set aside and directed that an investigation be opened. The house in Lennox stayed. Marvelle Mensa Cole heard the news from Zadie, who drove to the rehabilitation center in Hamilton on the day the ruling came and sat beside her grandmother's chair and read the decision to her, slowly, pausing at each point to let her understand. When she finished reading, Marvelle reached out and put her hand over Zadie's. She could not say what she wanted to say. The words were still difficult, still like carrying water in cupped hands. But she squeezed. The investigation that followed involved the Law Society of Ontario, the Real Estate Council, and eventually the Peel Regional Police Financial Crimes Unit. Rutherford Aldous surrendered his license to practice in May. The numbered company was found to be linked to a series of similar transactions involving elderly property owners in the Hamilton-Niagara corridor. 5 other cases were identified. Charges were eventually laid. Patricia Mensa Cole was interviewed as part of the investigation, whether she had understood what was happening, or whether she'd simply been told it was above board and chosen not to look too closely. That question, Zadie says, is not one she has a clean answer to. It's the kind of question that sits in the background of every family dinner, the kind you live alongside. Marcus flew in from Edmonton the week after the ruling. He stayed for 5 days. He and Zadie and Desmond drove Marvelle back to the house in Lennox, together, the 4 of them, on a Saturday afternoon in April, when the cold had finally started to lift and you could almost believe spring would arrive eventually. Marvelle walked to her garden on the arm of her frame. She looked at it for a long time. She said 2 words slowly, with effort. She said, "Still here." Desmond graduated from Sheridan in June. Zadie, in September of that year, enrolled in a paralegal education program at Humber College. She's in her 2nd year now. She's not doing it because she thinks she saved the day. She doesn't talk about it that way. She does it because she walked into a room where a courtroom full of people thought she had no business being there. And she had done the reading. And she had done the preparation. And the one question, not a dramatic question, not a Perry Mason moment, just a quiet and specific question about a date, had been enough. Preparation, she says, is the only thing that actually levels a room. She keeps Desmond's highlighted copy of the Notaries Act in a folder on her desk. He wants it back. She tells him he can have it when she's done with school.